The first issue is if you're starting to talk to tier ones, what should you do as a very first thing before you start to talk to them? We've advised offending organisations, organisations who offend, assist offenders for a long time, and there are a number of unpleasant war stories of the voluntary sector and community organisations dealing with larger commercial providers. To give you an example, SOVA, who we advised, spent a long time developing with a prime, who I won't name, a bid to do a particular large-scale service in the prison service, and a week before they were due to sign up the contract, the prime said they had recruited the development director of SOVA and a couple of their staff and were going to deliver the programme themselves. And when SOVA said, isn't that something of a betrayal, the prime said, well, you didn't ask us to sign a confidentiality agreement, you didn't ask us to sign an agreement not to poach your staff and do the service ourselves, why wouldn't we do it? We have a duty to our shareholders to maximise return, and it appears to us that delivering this particular element of the service ourselves using your ex-staff will maximise our return. So one of the things is there is a cultural difference. If you're a director of a commercial company, you have a legal duty to maximise the return for your shareholders, and there are occasions when people from the voluntary and community sector fail to recognise this and don't take proper steps to protect themselves. So what are they? They're entering into a confidentiality agreement, and they're entering into clauses in that agreement by which the organisation, the tier one, promises not to poach your staff. Now, you may have other things you don't want them to poach, so some of you have programmes, intellectual property, that you may also want to protect. So think about, before having open discussions with the tier ones, what you want to protect. Secondly, the tier ones may be seeming to indicate to you that they'd like you to be exclusively in their supply chain. I think unless you're absolutely confident that this tier one is going to win, you want to be in all the bidders' supply chains for the areas that you're in. So, as with everything, understanding as much as possible about it, reading the background documentation is going to be important to you for two reasons. One, for negotiating and managing the risk of this whole process, and the second is marshalling your arguments. There's a lot of material coming out of the MOJs in which you can see their good intentions. I happen to be a little cynical about the degree to which the ISPA is actually going to offer many of you very much protection. There are various mechanisms in it, but I think they're remarkably ineffective. And they're mostly about transparency. So, to take an absolutely central issue, the management of risk. The ISPA is very clear that risk should be managed appropriately. You have to go sign a questionnaire saying you've considered the management of risk and this is something you have to tick. It doesn't say that it's appropriate or you're happy with the way risk has been managed. You just have to say you've discussed the management of risk. So the ISPA contains intentions to improve your position, be it vis-a-vis tier ones, but they're not necessarily terribly effective. You need to think, obviously, ahead about whether you're going to be comfortable with living on just a fee for service and how you're going to feel about payment by results arrangements. And you need to identify key points that you feel that you are going to be deal points for you. Clearly, tier ones, if they're seeking you as part of their package, at this stage, before they win a contract, you offer something very important, often referred to as bid candy. And how do you avoid being bid candy? Well, it's actually very hard to avoid being bid candy because they will tell you that their contract prevents them offering you guaranteed volumes of work. And clearly in the past, organisations have worked hard to be part of the supply chain only to find very small amounts of work coming their way. But there are other ways in which you can seek to quantify it by talking about percentages of the work that they get, and you also need to think about whether the particular service you supply is sensitive to the types of client that are referred to you. Because, again, there's a nasty process called parking and creaming, whereby occasionally tier ones take the easy to achieve results in terms of prisoners or ex-prisoners or offenders, and pass down to the supply chain the difficult and hard to manage people. So you need to have clarity in what your offering is and exactly who it applies to, otherwise you may not, post the tier one's victory, get the sort of work that you want. The payments at the moment look like monthly in arrears. For some of you, gearing up for this organisational change and the sort of contract is going to generate cash flow issues. You need to have understood what those will be for your organisation and how you're going to deal with them. You need, I think, to try and get agreement from the tier one that they will keep you in touch with the bid, and clearly there will be some parts of the bid which are commercially sensitive, but large parts of their bid will not. If you're going to be associated with it as a supply chain partner, you need to see it, and I think you need to also get assurances at this stage that if they win the contract, that you are allowed to see relevant parts of the contract, so that in terms of what is being subcontracted to you and how it's being subcontracted to you, that you can see whether you're being given a fair shake of the stick. Clearly setting up good liaison arrangements and modelling the financial implications of winning bids. Winning bids has sunk quite a lot of voluntary sector organisations. So getting new, expensive to run streams of work may be exciting, but you need to know whether, having modelled it, your organisation is capable of absorbing it. Because there is a tendency within this process for the contractor to want to subcontract with as few people as possible, offering large contracts because it makes the whole management process easier for them. Are you going to be able to cope with these potentially larger streams of work than you previously did? Yes?
Can I just ask, at the top of that previous slide, you said that the tier ones will say that they can't give you some of this information because their contract doesn't allow it.
No.
Is that true?
Almost the most important thing for you is how much work am I going to get out of this if I'm on your supply chain. Now, very strangely, the contract that the tier ones are signing, not the ISTA, which is the subcontract, that contains a clause put in by the Ministry of Justice saying they can't guarantee you volumes. I don't know, I do not understand the purpose of it, and it may be that in later iterations of this tier one contract it will disappear, but I think you need to get some sorts of assurances that if you're going to join with them in perhaps supporting their bid, what will you get out of it? So one of the issues will be who else is in their supply chain. So if your direct competitor is in their supply chain, you need to have a frank discussion now about, well, you've got X in your supply chain and us. What is the division between the two of us going to be? Is it geographical? Is it a percentage? So if you don't get that assurance, now those assurances probably won't be binding. If you don't have them, then you haven't got any negotiation basis afterwards. I think you do, all entering this process, have to be clear that you may not win, and that it's the result of this whole process may be that your organisation may become radically smaller than it was. Do you have strategies for that unattractive outcome? What would happen if work that you're currently doing was given through an ISPA to some other tier 2 provider? Have you looked at issues such as merger? Are you sitting on a large premises with a termination clause that's about to expire, which you perhaps should serve notice on? Do you have staffing arrangements which are flexible enough to allow you to downsize if you've lost this? So I don't want to be miserable. But how do we get on to the next one? So those are the sort of initial issues that I think we need to think about. And I would just, the reason I started with a story about a rather unpleasant tier one is that the voluntary sector is largely collaborative, very often trusting. This is not a collaborative trusting process. This is, in the main, tier ones who are intent on running an appropriate business structure. Certainly they will want to have appropriate relationships with you, but those relationships will not include giving you one penny more than they have to give you in order to achieve the results they need. And for some voluntary sector organisations, that cultural leap is rather a difficult one, and people entering into those negotiations say to me, oh, well, we were assured that this would happen. And I said, is there a piece of paper that covers that? No, I don't think it ever got written down. And you just think, how can you have used that sort of approach with that sort of potential partner?
Can I just explain something quickly, because we're going from module 10 to module 1. The guide is set out in 10 modules, but as we've developed this presentation, we put different modules together, so we're kind of jumping around a bit, but the module numbers are related to the modules in the guides. Just to clarify why we're up to module 1 after module 10.
Yeah.
Sorry, can I ask again? We didn't get that guide.
You didn't get
Is it worth us having it now?
Yes, it should be on your seat, so I will get you a copy in the break.
Okay, so the industry standard partnering agreement is a contract, not a grant. However, if you are talking to a tier one, tier ones are given the power to continue grant funding. So how they're going to use that power, they are not obliged to work with you using the ISPA model. They can simply grant fund. Now, one would imagine that the grant funding is largely going to be where they're engaging with much smaller organisations at perhaps tier 3 organisations. You also need to talk to your tier 1 organisation about are they going to want you, having been subcontracted from them, to subcontract to tier 3 organisations. So are you putting together a package of perhaps community-based smaller organisations who are going to extend the scope of the contract that you're running? The second issue is that the ISPA contract is, when you read it, is relatively short. It's short because huge amounts of it are set out in schedules which are blank. So there is, although we've talked about giving the protection of the ISPA doesn't contain very much. A lot of the key provisions are there for discussion. They're up for discussion, and there's not even a basic framework, for example, about how payments are going to be made to you. So the presumption that there will be any reflection of the way tier ones are paid in your contract is one you may have, but you need to explore now with the tier one how they expect the payments arrangements that you're going to go forward. So are you getting purely a fee for service, i.e. a fixed fee, or are you getting onto that process which will move you to payment by results? So these are all things that it would be very good if you could sort out at this stage. The other problem about the ISPA contract being a subcontract is that it's all subject to the tier one contract. So all the provisions in the ISPA must be compliant with the tier one contract, which means you need to know what the tier one contract looks like. Otherwise, there's a risk of your tier one provider saying to you, oh, I can't do that because it's contrary to my contract, which may or may not be the case. So you do need to see it. There are some good things in the service agreement, the tier one agreement, and you should go through it because it provides you with a kind of checklist of what you can negotiate and what you can't. So if there is a requirement for a particular period of termination in the tier one agreement, clearly the subcontractor will not be willing to give you a longer period of notice than it is itself subject to under the tier one agreement. So it's quite straightforward in those provisions, and you will find some provisions in there which you may find helpful, which you'll want particularly to make sure do get carried through into the Tier 2 agreement. The risks in this contract are open. Despite the best attempts by the Ministry of Justice, there is no process in the ISPA contract that genuinely provides you with any sort of solid protection. It talks about, and this is also talked about in the main contract, it being inappropriate to pass down to you risks which would seriously damage your business. But I will be amazed if the Tier 1s do not pass risks down to you which would seriously damage your business. Now, having said that, you can say, well, their head contract says that they mustn't do it. What can we do? Well, there is the secret shopper process by which you can go to the Ministry of Justice, or you could go explicitly to the Ministry of Justice and say, this risk being passed down in this Tier 1 contract to us is going to seriously damage us. Well, first of all, the Ministry of Justice is overwhelmed with work at the moment with this project. Everything's running slow. So how much time have they got to get involved in one of, is it 21 or 23 Tier 1 providers sorting out its dispute with a Tier 2 provider? It might do if you've got a supportive local MP and questions being asked in Parliament, but you obviously got to think about what are the techniques, if any, that you're going to use to apply pressure if you see things being done completely inappropriately. And each application of pressure has its own consequences for you, because the Tier 1 is not going to love you if its behaviour gets questioned in a parliamentary question or something of that sort. So how are you going to do that? So one of the other issues you might think about is if there are a range of your sister organisations who are Tier 2 organisations, are you going to try and put together some formal or informal network so that you are in a better position with your Tier 1 to say, we all don't like this? That's a great deal more powerful than the individual. Now, I realise there are difficulties. You are, some of you, competitive with other Tier 2 providers in your area, but it should be possible for you to share some information in a way that would assist you getting a fair deal in this process. So I would strongly suggest that you look at your relationships with other potential Tier 2 providers and see whether you have any interests in common and places that you can collaborate. Yes?
Sorry, can you explain, or you mentioned something about the fee for use?
Fee for service. So I'm just going to repeat that.
No, there's a fee for service and there's a fee for use as well, which is basically the spot purchase.
The spot purchase. All right.
Yeah, it's a spot purchase. I mean, it's just a different way of referring to spot purchase. Why they feel necessary to invent an entirely new language. So I think in some places it's quite clear. We're talking about Tier 1s, not primes, because primes are getting an increasingly bad press. So we've relabeled them so that they're new. It's like Sellafield. What was it called before? The nuclear waste disaster, and it's now called Sellafield. So it's just it's largely a naming issue, I think. And the other thing, obviously, is that contractors. Some of you will have been in grant situations with NOMs. Our experience is that NOMs have not been particularly brutal about enforcing the terms of funding agreements or even contractual agreements, where they can see there's been real reasons why you have not achieved something. Those constraints don't really apply to the Tier 1s in quite the same way, and the culture is likely very different. You're not going to be dealing with civil servants who are keen to see you preserved and continuing delivering an outcome that they believe in. You're going to be dealing with a Tier 1 who may be thinking that what you've done is useless and they could do it better themselves, and it would be nice to enforce the terms of the contract. So do remember there's a difference in culture. I don't want perhaps to overdo it. Grants and contracts, for some of you, none of this is new, but it is worth ensuring perhaps at board level that people are aware what the difference is going to be if you're moving from grants to contracts. Clearly, one of the major differences is if you are able to organise your affairs so that you can make surplus out of these Tier 2 contracts under the ISPA, you're going to be able to retain it. There's no question of these being restricted funds. Yes, sorry.
Can I just ask, you said on the last slide about Tier 1 still being given the power to continue with grant funding.
Yes.
Is there any guidelines or any...
I couldn't find anything. Have you seen anything? It's just a provision in the contract which talks a lot about the supply chain.
So that's in the contract between...
Tier 1s and government.
Do you want to say?
Just really briefly, yeah. It was indicated when the competition first opened that the laws of the MOJ were very happy to see Tier 1 give grants, considering grants. There's been absolutely nothing that would look like best practice, that would look like any sort of rough guide to how many or how long they should be. It's going to be very much in the box marked discretion, at the discretion of Tier 1s.
And
but that's very much something that, as an organisation, you can have a conversation with.
Yes.
You can have a conversation with them. I think one of the concerns I'd have is that if you've got a large, commercially savvy Tier 1, it's likely to want to largely replicate all the conditions, terms and restrictions that you'd find in a contract in a grant, so that you may argue hard for a grant and end up having something that looks just like an ISPA, but is labelled grant. Now, clearly, there will be small organisations where they may have the sense to realise that, you know, they're putting bread on the water. Maybe the Somali ex-offenders community group can deliver and maybe it can't, but there's not much point in having an elaborate agreement with that organisation because it barely exists. The other thing is obviously is that grants generally, apart from involving you in doing something, don't deal with risk. This contract deals with risk a lot, deals with it through insurance, and will be dealing with it through provisions, particularly provisions dealing with change. The Tier 1 contract recognises that there may be legislative change that could change cost. It's very tight in that it says that any current legislation or even legislation on the slipway will not count as change. But you need to ensure that those change provisions in the main Tier 1 contract get carried through into your contract so that detailed provisions which may need to be changed can be changed in that way. Where am I on time? No, I'm all right. Even the ISPA terms are not guaranteed. So even if you say it's in the ISPA, the ISPA itself can be changed. There are and again, this is why you keep having to look at the Tier 1 contract. There are certain things in the Tier 1 contract which require Tier 1 providers to do with their subcontractors, and obviously those are reinforced in the ISPA. But there are other things in the ISPA that are not referred to in the Tier 1 contract. It is very difficult times. Many organisations will see this as a threat to their existence. I do think boards have to think very carefully about what your mission is, what your values are, what you're being asked to do, and whether you should be bidding for an ISPA. It's very difficult as a staff member, perhaps, whose livelihood depends on continued funding for their organisation, to do this objectively. But there will be organisations whose ethos and approach is inimical to some of the issues and things they're being asked to do under the ISPA. And what's harder is that the ISPA will contain change provisions so that you might, for example, start off being offered money to run a day centre and then find that you're required through the change provisions in your ISPA to run something which is much more coercive and which doesn't fit with your own culture. So you may wish to say that are in your discussions with the Tier 1, our values are these. We want provisions in our ISPA that we will not be required to do anything that contradicts these values, so that you can't use the change provisions in here. So some years ago, I was working with a children's charity who was running children's homes, and they put in specific provisions that they would not be required to run what they regarded as rather penal secure units for difficult children. And the local authority had said, oh, well, you're not doing that. But when we tried to say, you can't make us do it, suddenly there was a great deal of resistance, because clearly they had thought that maybe at some stage they would pass over their secure units to this charity, and the charity was very glad to have provided that it couldn't be forced to do that. Yes, please do.
Is this something that we can access the helpline to help us establish when it comes to any kind of conflict like that?
So can I just clarify?
So writing it
in terms of if you are getting into, if you're talking to a Tier 1 at this stage and you would like to get further legal advice and clarify those points, please phone the helpline or talk to me at the break, and we can see if we can look at that.
We're beginning to feel some of them rising, and it would be really interesting to kind of get.
We'd be really happy to talk to you about that. And yes, and generally yes, if you phone the helpline and talk it through, if you're getting into detailed discussions, we would be looking at passing on for legal advice. The legal advice is only available for free for small and medium organisations, but we can pass on some things. Yeah.
Okay. Confidentiality, yes, quite understandable that these contracts will contain confidentiality provisions, but look at them carefully. They may have an impact on your ability to campaign if you're a campaigning organisation. One of the things that you're going to do is to have to work through the multiple provisions that you're going to find in these contracts. Perhaps the most difficult area is the term and termination. How long is this going to go on for? Because it can be terminated quite understandably if you do wrong, but you can also lose your contract because the Tier 1 has made a mistake and had its contract terminated. The Ministry of Justice can step in certain circumstances. There are multiple ways in which this contract can come to an end. So while if you are delivering a service that needs to be delivered and you're the only provider, you may feel secure. But if you've got a more peripheral service, you need to be aware that there's all sorts of ways in which this contract can come to an end. And that will affect how much you invest in it. Tax and VAT, clearly the biggest issue is VAT. For those of you who aren't already registered with VAT and familiar with it, it may well be that the contract you contract to provide is VAT chargeable, and that may produce enough income in your organisation to trigger a need for VAT. VAT is run by customers, people who used to work in customs and excise. They have no sympathy with the voluntary sector in our experience. Direct tax, run by the Inland Revenue, pandas compared with the customs and excise. So please, please, please be absolutely clear about the VAT consequences of what you're doing. And remember, sometimes the VAT consequences are different if you're running the service through a charity than if you're running it through a trading subsidiary of the charity. And there are a whole range of issues about VAT saving that you need to explore in detail. For charitable organisations, obviously, the tax on any surplus is not an issue, provided they apply it for their charitable purposes. For other organisations who may be moving from grant, remember this is a contract, and even if you think of yourself as not-for-profit, if you're, for example, a community interest company or you're something else, you may need to think about how you're going to launder the surface, any surpluses to try and hit the minimum amount of tax. So you may be thinking about setting up a charitable subsidiary in which to bank surpluses. I think we're going to the next one.
Yep. Just keep going.
Okay.
Oh, you want some liabilities? Can we do liabilities?
Liabilities. I just think that you will recognise that the contract itself brings on greater liability in terms of exposing you to damages claim, but then what will happen is that the contract will not only expose you to damages claim, but will contain provisions for indemnities. Now, indemnities indemnities are used by lawyers to widen the liability of the person paying beyond what they'd have to pay on damages. To give you an example, we worked with somebody who had a contract with a local authority, and there was an indemnity provision for any extra cost that they incurred. There was allegations in connection with the children's home, and the local authority decided to set up an inquiry, hired a QC who charged, I think, £3,000 a day to look into it all. And under the indemnity, this charity had to pay the full cost of the inquiry, which exonerated them. Under damages, if they'd not had any indemnity provisions, they would not have been liable for those extra costs. So do remember that indemnity provisions are very different from other liability provisions. Now, you do have to just touch base with the basics in terms of governance. You've heard how these new areas, the Tier 1 areas, are going to be different from previous areas. Many organisations have geographical limits on their work. Are you going to have to review and change those geographical limits? If you are a charity, you're going to obviously need to get Charity Commission consent for any variation. Or the Tier 1 may be seeking to suggest you move into new areas of provision. Do they fit within your objects? So any of you who are charities are absolutely bound to only undertake work that falls exclusively within your objectives. And quite a lot of charities have objects which aren't wide enough. To give you a quick example, a couple of years ago I was visiting a large and extensive community facility in London which provided facilities for ex-offenders, had a stroke club, a mother and baby and toddler unit, and we'd taken over as their lawyers and were reviewing their governance for them, but they couldn't find their government document, which is always slightly anxious-making. I was walking round this facility, which was very impressive, Victorian but still in good condition, with the chief executive when her assistant found the constitution and rushed up to us, and I was reading the objects as we were going around. And I turned to the chief executive and I said, well, how do you check that everyone here is lactating? And she looked at me, and there had been very few lactating men in the stroke club we just left. And I said, well, you know, your objects are for, to assist nursing mothers and their children. This charity had been set up in the 1920s in an inner city slum. Most women who weren't menopausal had children at the breast. It basically was a centre for all women, and that was the phrase originally used. They had grown and they had never revisited their objects. They continued to do stuff in the spirit of what they were doing, but what they were now doing was wildly ultra vires. So it is important to look at what your objects are. Charity Commission and company law are all much more concerned about the proper management of conflicts of interest and conflicts of duty than they used to be. You need to look at your own procedures. Do you have proper processes for disclosure, both by staff and by trustees or by members of the board, of all their interests and of all the people they're connected with? Most of them forget about that. And do you have ways of dealing with that? And just look at this new contract and say, how if at all, does it raise interest, conflicts of interest, or conflicts of duty? Do remember that we're not just talking about financial benefit for a member of your board, we're talking about the fact that someone on your board may also be on the board of another organisation which is also bidding for an ISPA. How are you going to manage the conflict of duties that arises where somebody on your board is actually working with a competitor? Are you going to have confidentiality arrangements? Are you going to redact documents so that they're not aware of what's going on? We've talked about missions and values. campaigning and the confidentiality clause, it's a broad clause, you do need to think about how, if that's part of your vision. And who else do you feel yourself accountable to, and how will they feel about this new move for you to take over this work? How are you going to communicate with these people and manage their expectations? Boards aren't all perfect, and what you're going to be doing may well be producing rather challenging times for the strategic management of your organisation. When did you last look at whether your board is fit for purpose and has the skill mix necessary to achieve this? Very many boards have people who are good people, but perhaps relate to a period when you were a smaller, less complex organisation in less competitive times. So you may well have to revisit the composition of your board, or at the very least check that you have on the board appropriate skills. And if you don't have those skills, how are you going to supplement the skills on the board? Are you going to pay for professional advice? Are you going to bring people in as advisors? How are you going to support them through the process? Because they will be needing to make quick decisions, and they will also need to manage the process of you negotiating the ISPA and then the service delivery itself. There may be doubt about whether you should go forward. That doubt may mean that the board wants to reconsider issues, but you've got a tight contractual timeline which will be playing out ahead of you. How is there proper authorisation and delegated authority so that the key decisions can be made in time with a schedule of decision making probably set by the Tier 1, which may not fit with your own board cycle. So do you need to revisit and establish and properly document the delegation process? Having won the contract, hopefully for you, what process are you going to put in place to monitor it? It may be larger than other income streams that you've got. It may be viewed as higher risk. So what processes are you going to put in place to ensure that it's managed? And are they transparent? So I'm very keen on traffic light systems where board members are very clearly alerted by it being given a red if things are going off the rails, if you're not reaching target numbers, or you're having other problems. And finally, board members may need to be reassured about their personal liability. For those who've had grants and become aware of the greater risks of contracts, they may believe that they are personally liable. Clearly, this is not the time to be an unincorporated organisation. If you haven't already got the protection of limited liability through being a KIC or a CIO or a company or an industrial and provident society, you're going to need to think very carefully about taking one of these contracts if you're a Royal Charter organisation or unincorporated association or trust. One solution to anxiety about risk is to set up a subsidiary and run this contract through the subsidiary to put a firewall between you and perhaps historic reserves and buildings that you've built up and the liabilities that may arise from this contract. The problem is, will the Tier 1 accept that the contract is going to be placed with an essentially asset-free, no financial history subsidiary? And the other thing is, if you're going to see it as a way of managing risk, then you need to be clear that you'll actually use it for that, because quite often I've worked with organisations who've set up a trading subsidiary to manage risk, and then when it came to that organisation becoming insolvent, they haven't been prepared to let it go down the tubes and become insolvent because they felt morally obliged to look after it, and that produces even more problems than if they hadn't set the whole thing up through a trading subsidiary in the first place. Yes.
Ask another quick question. Just picking up on the point you made about asset-free, do you envisage that to be an issue with the Tier 1 contractors? If we're
Well, Tier 1s are
asset-free?
going to want as much reassurance that when you sign an agreement, you have the asset backing and the history to mean that if they want to enforce against you, they can, and of course that you're able and stable enough to deliver the service without causing them problems up the tree with noms. So they're going to be, many larger organisations will only contract with people who've got 3 years accounts and a sufficient asset base. Whether that'll be the case in this particular circumstance will depend on the rules that your Tier 1 set itself, and also your own negotiating position. You may say to a Tier 1, I'm afraid my board won't do this contract with you if it doesn't run it through a subsidiary. And if you're important to the Tier 1, you have a service they can't readily source somewhere else, they may accept it even though they don't like it. Yes.
I was just going to say that. Basically, if they've got to meet all of the protected characteristics, they're going to have to look at small Tier 3, Tier 4, Tier 5 companies, because they're not going to be able to tick that box. But those Tier 4, Tier 5s are probably not going to be in a position to manage liabilities, because they have to set something up to engage.
That's certainly the case. So although setting up a trading subsidiary is not complicated, what is more complicated if you're a charity is the relationship between, and the proper documentation of that relationship between a charity and its trading subsidiary. The other possible use is that if you are providing a service in conjunction with somebody else, perhaps jointly bidding for some collaborative work, you may want to set up a special purpose vehicle through which to run this collaboration. And we'll talk about that in another slide. There will be a lot of liability that you simply won't be able to control or insure against. There's no way around that. That's just an issue that one faces. Just to confuse issues, the ISPA talks about governance in another way, and by which it means what are the processes that are going to be used to manage this contract. And those processes are relatively straightforward, and if you've had other contracts, you'll be familiar with reporting arrangements, meetings, and a range of other provisions. The concerns that some Tier 2s may have is that in order to reduce the workload at a Tier 1, they may require reporting to be done in very specific ways that are perhaps compatible with their own IT systems to enable them to streamline the reporting up the chain to noms. You need to be very clear about what those are, because they may have substantial cost implications for you if you're asked to make your material available in particular formats or using particular computer programs. Try and get that agreed. There's no reason that sort of thing shouldn't be agreed if you're talking to an ISPA beforehand, just to ensure that there aren't costs. The Tier 1 may be involved in discussions with noms about changes of service. Try and get agreement in your contract that you will be involved at an early stage in this, so that you don't simply get told after 6 months of discussions between the Tier 1 and noms that something you're doing is going to have to be done in a very different way. Again, within each organisation you need to nominate and clearly delegate authority to the people who are going to be running this. And finally, I've been a little uncharitable from time to time about the Tier 1, but you are getting in bed with them. You need to form relationships. They're human beings, and you will find that this contract will go hugely better if you invest very substantially in making relationships with that Tier 1 organisation. We all know that if you've got a personal relationship with somebody, you will tolerate the occasional departure from the standard of best practice, whereas if someone has been a complete pain in the neck, or you simply don't know them, your standards are going to be much tighter. So within your organisation, both at trustee level or board level and in the staff, you need to think about how are you going to build those relationships with the tier one. And the problem at the moment is you may having to do that initially with a number of tier ones because you don't know who's going to win. Questions? Yes.
It's not so much a question as an observation. We're a very small organisation ourselves. Where we've benefited, not in this because it's being set up, is in small consortium at tier 3 levels, where we worked with somebody who is already being contracted by a prime, as they were, tier 1 as they are now. But the frightening thing for us has been the number of organisations around the table whose constitution forbids them from getting involved in anything speculative. But the draw of the lure of the cash has put all of that to one side. And I think your first port of call, if you're going to get involved in this kind of work, is to look at your mem-and-ups and either decide whether the risk of amending them is worth the payoff, possibly exposing your trustees' limited liability.
Okay. I do think that there is a lot of anxiety at trustee level and at board level about personal liability. Limited liability is very much designed to protect those board members. I've looked after board members in a big variety of for-profits, not-for-profits and things. And the number of times when someone tries to make them personally liable is very, very small indeed. So I'm generally rather reassuring to board members about their personal liability. They often come to me and say, well, why don't we insure ourselves? And the answer is, sadly, you generally can't insure your debts. And so limited liability is the big protection. However, insurance may be something, if you've got an anxious board, that you need to pay for. Because I talked about the decision-making process in governance. If you have a board that's anxious about this, one of the things it'll do is delay it and reconsider it and stuff. You may lose the contract or ability to contract properly because your board is too nervous to go forward. If entering into some trustee indemnity insurance or officers insurance helps them to go forward faster, it may be a good idea, even if that insurance isn't worth very much.
But that only applies if you have knowingly taken that insurance out, not intending to do anything that might breach it.
Yeah, well, I think none of them intend to do anything that might breach it. They do that. Don't come across that very often.
I think knowingly and willfully are,
I think the insurance is pretty useless, but it's very reassuring. That's my view.
Okay, I'll take one last question, then we're going to break for coffee. Sorry, could you say who you are and where you're from? Sorry, I know.
Going back to previously mentioned about the stock purchase, one of the things I was trying to, I thought you might have mentioned, there's a recommendation that tier 1s offer contracts to tier 2s where it's more or less beneficial to the tier 2. But if you find yourself in a spot purchase situation, when does a spot purchase become a contract?
A spot purchase is a contract. Can I give you an example? If you were running a day centre for former offenders, if you got a monthly payment to run the day centre, and it was assumed you'd look after 100 people there, that would be an ordinary contract. A spot purchase would merely be that whoever was nominating it would nominate prisoner X, prisoner Y, prisoner Z, who would have a right to use your day centre, and you'd get paid individually for those individual prisoners, or former prisoners. So it's merely a different way of doing it. The difficulty with spot purchase generally is you have no idea about volumes, and they can change very quickly. And the other thing is that spot purchase is that very often you've agreed a fee per person, assuming certain levels of needs, problems, or challenging behaviour, or whatever else it is. And if the tier 1 does any parking and creaming, it may well send you all the difficult, challenging people, and you can only have 6 in a group, whereas if you had less challenging, you could have 12 in a group, so your cost double. So that's the problem with spot purchases generally. But they use it just normally means per head purchase rather than by group.
Can I check something as well? Because I think there's also an issue here about when the ISPA has to be used with another organisation. And what the guidance is that if you are a Tier 2 organisation, it is a requirement that the Tier 1 uses the ISPA. And it is deemed to be good practice for organisations that are Tier 3. However, they won't give a definition of what that means. And I suspect somebody in the MOJ probably started the process thinking it would be nice and linear, and you'd have Tier 1s contracting with Tier 2s, big Tier 2s, and then Tier 2s contracting with small Tier 3s. That's not how it actually works. So that definition seems to be changing to be that the Tier 2s, which will be required to use the ISPA, will be delivering materially significant elements of the contract.
Okay.
Whatever that means.
Could I
So
just
there
say
will
that-
be so it may be that you're contracting directly with a Tier 1, but under a Tier 3 agreement, they won't be forced to use the ISPA. Does that help? Thank you.
Okay, and if you ask me to be cynical, I'm not sure how much difference it will make to you whether you get an ISPA contract or a non-ISPA contract, because I don't think that protections in the ISPA contract are so radically important that you'll notice them a lot. What will in all cases depend is how effectively you prepare for the contract negotiation process, how wide-eyed you go into the process, and how carefully you protect yourselves where you can by provisions in the contract. The ISPA isn't a terrible document, but neither is it a magical protection which, if you don't have, you're out in the cold. You could get just as much or indeed more protection in a contract you negotiated yourself. So ISPA, I think, is the Ministry of Justice's very worthy attempt to make the supply chain a better place to be. I think we shall all wait with interest to look in, say, 3 or 4 years' time about how many of you say, but for the ISPA, I'd have had a miserable time. I suspect whether you have a miserable time or not will depend on things like what sort of relationship you've got with the Tier 1 and how vital you are to them.